Thank you so much. I will call this meeting to order of the Nevada Senate Judiciary Committee on March 23rd of 2021. Will the esteemed secretary please take the roll?
Vice Chair Cannizzaro.
Please mark Chair Cannizzaro present when she arrives, and I'll try to make a note of it as well.
Senator Orenshaw.
Here.
Senator Harris.
Here.
Senator Settlemyre.
Senator Settlemyre will be late today. Please mark him present when he arrives, and as always, I will try to make a note of it as well.
Senator Hanson.
Here.
Senator Pickard.
Likewise, please mark Senator Pickard present when he arrives. I will try to make a note of it.
Chair Scheibel.
And I am here. We are also joined today by Mr. Pat Guinan from the LCB, our fantastic committee analyst. As always, Nick Anthony, our committee counsel, remains available to us to answer legal questions. He is busy drafting legislation for us and unable to join us live time in the meeting, but we can follow up with him if there are any questions. I do want to apologize to our presenters for our late start today. As I hope you already know, we were on the floor until just a few moments ago. And for that reason, I would also like to give all of the members of the committee permission to eat their lunch during committee and ask that our presenters please not take offense to their being human beings and not having had a lunch break today. So with that, I think we are ready to move on to our first bill presentation. We are going slightly out of numerical order to accommodate presenters' schedules. And again, I appreciate all of your patience. Let's open the hearing on SB 237. Senator Harris.
Thank you so much, Chair Scheibel and members of the Judiciary Committee. My name is Dallas Harris. I represent Senate District 11 in the southwest part of Clark County. And I appreciate you taking the time to hear this bill today. I'm just going to give a very brief overview of what the bill does, and then I will hand it off to the capable hands of Eric Jimenez and our State Treasurer, Zach Conine. And then following them, I will ask Tim Houghtonberry to speak a little bit about what this bill means for the LGBTQ business community in Nevada. So briefly, starting with Section 6 of the bill, because I think this is the crux. Section 6 of the bill includes a person who identifies as lesbian, gay, bisexual, pansexual, transgender, transsexual, queer, intersex, intergender, or asexual, or any other non-heterosexual or non-cisgender orientation or gender identity or expression in the definition of disadvantaged persons. And if we take that definition and the idea that we are also acknowledging that this group of folks are disadvantaged persons in Nevada, you will see where it flows backwards into the bill, where we're making sure that disadvantaged business entities include these folks as well. Back to Section 1. Section 1 of the bill simply adds LGBTQ businesses to the list of those who are entitled to receive information through the state business portal regarding public and private programs to obtain financing for small businesses under state and federal laws, and the process for obtaining certification as a disadvantaged business enterprise. Section 2 requires that the Office of Economic Development's program, the Small Business Enterprise Program, include LGBT-owned businesses as well. Section 3 makes it clear that the elimination of discrimination against disadvantaged business enterprises that are LGBTQ-owned businesses is important to the future welfare of our state. Section 4 includes LGBTQ-owned businesses in the requirement that is imposed upon the Department of Transportation to establish goals for the participation of disadvantaged business enterprises and local emerging small businesses in certain contracts. And Section 5 of the bill requires any subcommittee on market participation appointed by the chair of the Cannabis Advisory Commission to review and make recommendations on matters relating to LGBTQ-owned businesses in the cannabis industry in the state. Put most simply, we are expanding our idea of what it means to be a disadvantaged business in the state and attempting to acknowledge that we need to have diversity in all industries and provide all of the resources we provide for our other minority-owned, veteran-owned, and similar businesses to these set of disadvantaged businesses as well. I'll turn it over now to Mr. Jimenez and Mr. Conine.
Thank you, Senator, and thank you, Chair Scheibel and members of the committee. For the record, I am Zach Conine, and I have the privilege of being your Nevada State Treasurer. Throughout the past year, small businesses across Nevada's communities have struggled. Business owners have been forced to make tough choices as they've navigated trying to pay their bills and their employees in the midst of one of the worst economic downturns we've ever seen. Thankfully, through much needed aid from the federal government and through the leadership of Governor Sisolak and this legislature, vital assistance programs like the Pandemic Emergency Technical Support Grant Program have ensured that disadvantaged businesses have been able to keep their doors open. Broadly speaking, Senate Bill 237 is seeking to broaden that definition of the term disadvantaged business to be more inclusive in Nevada's LGBTQ community. By making this simple change, we can ensure that LGBTQ businesses can access the same type of assistance and loan programs afforded to minority-owned, women-owned, and veteran-owned businesses. As we work through Nevada's economic recovery, we're going to need to make sure that all of Nevada's small businesses have the resources they need. By elevating the voices of our LGBTQ business community, we can work collaboratively to create a state that is more inclusive and prosperous for all Nevadans. I want to thank Senator Harris for her leadership on this issue, and we'll turn it over to our Senior Deputy Treasurer, Eric Jimenez. Eric, as many of you know, has been instrumental in our pandemic response and recovery efforts. Eric?
Thank you, Mr. Treasurer and Chair Scheibel. For the record, Eric Jimenez with the Treasurer's Office. This bill kind of came to fruition as we were administering the PETS grant. About midway through the process, when we had gotten through about $30 or $40 million in approved applications, we realized that we were using the definition of disadvantaged business to prioritize businesses who needed a little bit of extra help during the pandemic so we could fund those applications first. And in one of the deficiencies of the law, after talking with Senator Harris, we realized that there was no way for us to identify which of those businesses were from the LGBTQ community. So we figured a simple change and conforming language in all of the statutes where LGBTQ businesses are listed would ensure that, whether we're providing information on assistance or grants or loans, or if there is additional aid from the federal government that goes to support small businesses in our community, we can make sure that those LGBTQ businesses are included and get the help they need. And I think it's incredibly important, and I think with the passage of SJR 8 right now on the Senate floor, that we know that we need to make sure this population feels included, particularly members of the trans community. I think it's important that they hear from their government that they are heard and seen, and they should be able to start a business and flourish just like everyone else. So that's it, Madam Chair. I know the Gay and Lesbian Chamber of Nevada is here to provide some on-the-ground experience, but if you have any questions, we're happy to take them.
Thank you. First, let the record reflect that Senators Cannizzaro and Pickard have joined us. And Mr. Haugenberry, are you from the Gay and Lesbian Chamber?
I am, thank you. It's pronounced Tim Haunberry, silent GH like in night. And I'm the president of the Gay and Lesbian Chamber of Commerce of Nevada. Thank you for having me here. So I guess I'll just jump right into it. I want to say thank you for considering this as part of Bill 237. It is actually extremely important to the gay and lesbian community. We've had a rough year like all small businesses. I'd like to say all of us did, but we have a lot of realtors that actually did very well. But all of our people in the convention services business, the entertainment business, modeling, event and expos, they all got hit really hard and they're still hit very hard. And although PPP helped, loans like this or programs like this are extremely beneficial. We've grown from over 30 members in the last 2 years to over 110 members from 30 in the last 2 years. And just on the Reno Sparks area, 18 in the last 3 months. So the growth is important on our end. This helps our companies survive. It helps them sustain, and hopefully it helps them become successful. And we really appreciate your consideration in making this part of the bill. Thank you.
Thank you. Senator Harris, is there anybody else who you want to give comments before we go to questions?
That would conclude the presentation, Chair Scheibel. We will submit ourselves for any questions that the committee may have.
All right, we will go first to Senator Hanson.
Thank you, Madam Chair. The question I have, obviously, with women or veterans, you can identify them pretty easily. A white male like myself, if I read this correctly, could simply identify myself as perhaps bisexual or asexual, and I would qualify under this. I mean, where's the standard of proof to show you actually are bisexual, heterosexual, homosexual, whatever? How do you prove that?
So, Senator, thank you for the
I could prove it. Actually, it's actually for certified companies. So to become a certified LGBTQ business, you have to be certified by the National, which is in over 5 countries, and they come out and they interview you independently to prove that you're an LGBTQ owned business in the state of Nevada.
So there is actually a standard that's required before people can apply for this sort of a loan situation. Now, how could you, even if I get interviewed, how would you prove that I'm not bisexual?
And if I may, Senator Hanson, I hear this question a lot, and the truth is no one is out there masquerading as a disadvantaged person in order to gain some perceived advantage. So the issues that you're raising in practice do not actually arise. And by the way, a small business enterprise already has a certification for LGBTQ owned businesses. The state does this already in certain areas. And so while I understand that you do not wear your sexuality necessarily on your sleeve, so to speak, this is actually not an issue in practice. And generally, these types of arguments are only used to prove or to suggest that LGBTQ businesses or even LGBTQ persons don't need any additional protections. So I hear you. I know the state can deal with this. This is actually not a legitimate, in my estimation, concern.
Well, I thank you for that. But however, I would point out that if in fact, at some point, this becomes a significantly advantageous thing for business people to take advantage of. For example, I will give you an example. When Nevada started to encourage women-owned businesses to have priority in bidding, in fact, a tremendous number of businesses in Nevada shifted to female ownership to take advantage of these kinds of programs. So while it is true that currently that may not be the case, that doesn't mean that down the road you will not have people essentially claiming to be members of a community that perhaps in their actual physical practices are not. But again, I don't see how you can possibly come up with a standard to prove that. I don't want to get into the details too much, but again, this seems to go way too far with way too broad definitions for people to fit into the category. Thank you, Madam Chair.
All right. Do you care to respond, Senator Harris or other presenters?
I do not.
Great. Senator Pickard, go ahead.
Thank you, Chair Scheibel. I am actually Senator Hanson's question raises raised a question, because if the representation is that these have to be certified LGBTQ businesses, I don't see that in the bill. Can one of you point me to, because it might be in one of the CFR, I just don't know where it is. So can we kind of get that on the record where that certification is required under this rule? Because as I read it, it just says a person who identifies as LGBTQ or has at least 51%. So it seems to me that a mere representation that they identify would suffice, but I just want to make sure that's clear on the record. That wasn't my question, but I think it's a good one to resolve.
And Senator Pickard, I'll just note, let's just in general stick to statutory practice, right? if you look at the bill, it doesn't outline how women-owned businesses have to prove that they're women, or how a veteran-owned business has to prove that they're a veteran. And so I am fully confident that these issues can be shaken out in the in practice. We have the treasurer's office on as well. And so there are verification systems in place for all of these categories, and I imagine there would be some similar verification process as well, but that is not in the bill, nor is it for any other category. Probably nor should it be.
Well, and I appreciate that. I just, I guess I don't, with those others, there are regulations that set forth the standard. For example, veterans owned, you have to be able to demonstrate you're a veteran. We had to do that in the federal contracting work that I had done. I had to gather that information and submit it. Are in place, and I don't see where in the bill that's required. Anyway, my question had to do with, does this create a set aside or an expectation of a set aside for this program?
I'm not sure I understand your question, Senator Pickard. Are you talking about money in particular to implement the program, or what do you mean by set aside?
No, when we're talking about the application process, the licensing, the recognition of this as a new additional program or classification, my guess is that this would be included in the government set aside for construction projects and the like, where there are quotas or requirements for a certain level of say, minority business. So for example, on the federal construction side, there's a minimum requirement for a certain level of minority-owned businesses or women-owned businesses. So I would assume that this is now included in that set aside for the now women-owned, veteran-owned, or now LGBTQ-owned businesses. They have to have a certain percentage of the subcontracted work. Is this program extending to those set-aside requirements?
So, Senator Pickard, to you through Chair Scheibel, it is my interpretation of the bill that NDOT, the Nevada Department of Transportation, would have to establish goals for the participation of these businesses. How NDOT decides to do that will remain the same as they've done for the program in the past. And so I don't unfortunately have anyone from the Department of Transportation on to maybe walk you through how they would implement the bill, but I'm happy to get someone to circle back with you about that if you'd like.
No, I think you just answered the question, and I appreciate that, because the answer is yes. If this is now one of those groups, that they would have to treat them or treat this new group the same way they do the others. And then when we're talking about the treasurer's involvement, we're talking about programs for grants and loans and that sort of thing for them, correct?
This is Treasurer Conine for the record. So the intention is to include that group within the disadvantaged business entities that we prioritized for funding, say, through the PETS grant, right? But much like the PETS grant or other future grants, there are certainly no plans to do set-aside buckets for specific groups, simply to make sure that as we're prioritizing, that we're taking systemic and historical and current barriers to capital, barriers to success into effect.
Okay, very good. I appreciate that. Thank you.
All right. Anybody else with questions? I see your hand, Senator Hanson. Today, however, we have 2 more bills to get through. You and I both have natural resources at 3:30, so we're not going to do second bites at the apple, but I encourage you to follow up offline with Senator Harris. If there are no other questions at this point in time, then we will move to testimony in support of SB 237.
Thank you, Chair Scheibel. Excuse me. To testify in support on Senate Bill 237, please press star 9 now to take your place in the queue. Once again, to testify in support on Senate Bill 237, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 069. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, my name is Andre Wade, Andre Wade, and I'm State Director for Silver State Equality, a statewide LGBTQ plus civil rights organization here in Nevada. Thank you, Chair Scheibel, Vice Chair Canizaro, if you are there, and members of the committee. We are in full support of this bill. Disparities are across the board for the LGBTQ community, not just in health outcomes, but also in business, as outlined earlier. And so what this bill does just wants folks to be included in programs that already exist by creating equity. We're not creating a new class of people. We're not creating a situation where this particular community is going to have an advantage. If anything, they're going to be slightly in equal footing with these efforts. And so thank you all for bringing forth this bill to bring inclusion for LGBTQ folks who are business owners here in Nevada. Thank you.
Thank you, caller. As a brief reminder, we are currently on support testimony for Senate Bill 237. If you'd like to provide support testimony for SB 237 at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 130, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE I'm a policy director with the Progressive Leadership Alliance in Nevada. I just want to echo the testimony of the previous commenter and urge your support for this important piece of legislation. Thank you.
Thank you, caller. If you've just joined us, we are currently on support testimony for Senate Bill 237. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. And Chair, there are no more callers to give support testimony at this time.
All right, then we will move to testimony in opposition to SB 237, please.
Thank you, Chair. To testify in opposition on SB 237, please press star 9 now to take your place in the queue. Once again, to testify in opposition on Senate Bill 237, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 638, please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Thank you, Chair and members of the committee. My name is Alexis Motorex, Alexis Motarex, with the Nevada Chapter Associated General Contractors, representing the commercial construction industry in Northern Nevada. We are here today in opposition to SB 237, primarily Sections 3 and 4. While we appreciate and understand what the sponsors are trying to accomplish, we do have some concerns. The Federal Highway Administration, which provides a significant amount of revenue for our highway fund, largely sets the DBE participation goals in Nevada, and it does not recognize LGBTQ when setting those goals. LGBTQ business owners are currently eligible for the Small Business Enterprise Certification, which provides race and gender neutral business goals on both state and federal projects that do not have DBE goals. NDOT currently has several of these contracts. And lastly, we share the concerns about what safeguards would be in place to prevent fraud. With no way to prove sexual identity, unscrupulous people could be incentivized to state they identify as LGBTQ in order to take advantage of the programs offered under these classifications. Again, we appreciate the intent of SB 237 and would love to work with the sponsors and other stakeholders on ways to accomplish their goals. Thank you.
Thank you, caller. And as a reminder, we're currently on opposition testimony for Senate Bill 237. If you'd like to provide opposition testimony at this time, please press *9 now to take your place in the queue. Chair Scheibel, there are no more callers to give opposition testimony.
Thank you so much, Mr. Kyle. Then we will move to testimony in the neutral position on SB 237.
Thank you, Chair. To testify in neutral standing on Senate Bill 237, please press *9 now to take your place in the queue. Once again, to testify in neutral on SB 237, please press *9 now to take your place in the queue. And Chair, there are no callers to give neutral testimony on SB 237 at this time.
All right, thank you so much. Senator Harris, do you have any closing remarks?
I'll just say very quickly, thank you for taking the time, committee, to hear this bill. I think it's very important that we continue to assess the state of our citizenry, what we can do to help businesses across the state, especially coming out of the pandemic. And I am 100% sure that this bill will make the world a little bit better, one little pets grant at a time. Thank you.
Thank you. And I'm sorry, Treasurer Conine, Deputy Treasurer Jimenez, any other closing comments?
No, Chair. Thanks for having us.
Thank you so much for joining us today. And with that, I will close the hearing on SB 237. While you're welcome to join us for the rest of the meeting, you're also welcome to go. And that leads us to the hearing on, well, our next hearing, which is on SB 203. We are joined by our friend and colleague, Senator Don Darrow Loop, who will be presenting this bill. And whenever you are ready, please go ahead. I am now opening the hearing on SB 203.
Thank you so much, Chair Scheibel. For the record, I am Marilyn Dondero Loop, representing Senate District 8 in Clark County, and I am pleased to present Senate Bill 203 for your consideration today, alongside Allison Brazier and Robert Eglett, two attorneys from Las Vegas. The actual number of child victims of sexual abuse is unknown because so many do not report their abuse. In addition, many adult survivors of child sexual abuse never disclose their abuse to anyone. We all remember the news stories of the USA gymnastics team doctor who abused the children in his care for many years. At his trial, former gymnasts, many in their 30s, reported about the abuse 20 years later and more after it had occurred. According to the National Center for Victims of Crime, nearly every state has a basic suspension of the statute of limitation for civil actions while a person is a minor. Many states have also adopted additional extensions specifically for cases involving sexual abuse of children. Extensions for filing civil actions for child sexual abuse have most often been based upon the discovery rule. By the time the victim discovers the sexual abuse or the relationship of the conduct of the injuries, the ordinary time limitation may have expired. As I noted before, this delayed discovery may be due to emotional and psychological trauma and is often accompanied by repression of the memory of the abuse. Many states have extended their statutes of limitation for civil actions involving these cases, and some states have removed this limitation entirely. In 2017, we raised the statute of limitations for these types of civil actions from 10 years to the current limit of 20 years. Senate Bill 203 removes that limit altogether. This is critical in achieving justice for survivors in civil suits because it is a powerful tool for deterring the bad actors. At this point, I would like to walk you through Senate Bill 203, just highlighting the major provisions. Section 1 changes the statute of limitations for filing a lawsuit to recover damages arising out of sexual abuse or exploitation committed against a minor, including injuries suffered by a victim of pornography involving minors. This bill removes the existing 20-year limit and specifies that the action may be started at any time after 18 years of age. Further, this section provides an exception to identifying a specific incident that caused an alleged injury to the plaintiff. It also includes a definition of unwanted sexual contact. Section 2 contains several major changes to the law. First, it provides that in civil actions involving persons other than the convicted abuser, the previous conviction of the person actually committing the offense constitutes evidence in the action that the person sexually abused or exploited the plaintiff. Second, the person other than the convicted abuser is liable for damages if that person had any employment relationship or responsibility for the abuser, if that individual owned the property where the abuse took place, if they knew or should have known the abuse or exploitation was taking place, or if they allowed it to occur. Finally, Section 2 provides additional damages for a person who is liable to the plaintiff other than the person convicted of the crime. If that person gained a benefit or covered up the abuse or exploitation, the person is liable for treble damages. The next provision is contained in Section 4. The section states that the changes made in Senate Bill 203 allow the liability for recovery of damages to apply retroactively to incidents of sexual abuse or exploitation, or to any act involving pornography and a minor, even if the statute of limitations had expired under previous law. In effect, it restores the ability of a plaintiff to take civil action that was previously barred by a 20-year limit. To conclude, this change in our statutes is long overdue. The survivors of sexual abuse and exploitation deserve a civil forum to pursue their abusers and those who allowed their abuse or exploitation. The treble damages in the bill are intended to be punitive as a deterrent to those who aid and abet or turned a blind eye to the abuse or exploitation. Finally, I would like to point out that we do not have a statute of limitations for homicides. These crimes are a form of murder against a minor, since they kill their innocence and destroy the life of that child. Removing the statute of limitations for civil actions involving these crimes may provide survivors with some small measure of closure. This concludes my remarks, Chair Scheibel and committee, and I would like to invite Allison Brazier and Robert Eglett to add to my remarks. Thank you very much.
Good afternoon, Chair Scheibel and members of the committee. My name is Allison Brazier, and I'm here on behalf of Nevada Justice Association. I'm also here with Mr. Eglett to answer any questions that the committee members might have for us. The intent of this bill is to stop human trafficking, sex abuse, and exploitation of children in Nevada. And before I go into the details of the bill, I just want to give the committee members some numbers and statistics that to show you the scope of what's happening here. According to the National Human Trafficking Hotline, which collects those reports of human trafficking and abuse, between 2007 and 2016, there were over 1,600 calls just in Nevada to report suspected cases of human trafficking. Of those calls, in Las Vegas, almost 500 cases were actually opened. That puts us number 6 in the nation. And in Reno, 51 cases were actually open, which puts Reno at number 64 in the nation. So when you look at those numbers together, we were averaging a little bit more than 1 case per week that was actually opened in the state of Nevada. And we know that those numbers are low because of the underreporting of these crimes. So, you know, 1 victim of child sex trafficking is too much, but having 1 case per week opened on average during a span of 9 years, I think should be shocking and concerning to all of us. And that's one of the problems that this bill tries to address. So in section 2 of the bill, we are expanding the parties who may be held liable for this type of abuse against children. It allows victims to seek recourse not only against the actual abuser or perpetrator, but against the pimps and the businesses who allow this to occur. Now, while we know that the pimps, the traffickers, and the other abusers are the primary source of this injury, they don't work alone. They rely on businesses who turn a blind eye to this sort of behavior and criminal activity in their establishments. These are hotels, motels, truck stops, nightclubs, other unsavory, I'm not saying that those categories are unsavory businesses, but bad actors in the community who turn a blind eye and provide a location for this type of abuse to happen against our children. And while we know that there are criminal punishments available to these individuals, arresting one pimp or one trafficker or one abuser at a time isn't going to get to the heart of the problem. Through this bill, we feel we need to financially punish these bad actors, these businesses who allow crimes against children to occur, by putting a financial connection to this type of behavior. We believe it will incentivize businesses to train their employees to be the first line of defense against spotting this type of sex trafficking and exploitation of children, because many times they're in the best position to identify and to stop this behavior from happening, this criminal activity. But I do want to be clear that this is not meant to open the floodgates to lawsuits. Section 2 of the bill clearly spells out that there are 4 factors that need to be met before a business or other individual can be held liable. So first, they must, a person or business can be liable if they employ, supervise, or have the responsibility for the person convicted of the crime. 2, they have to have owned or controlled the property upon which the sexual abuse or exploitation occurred. 3, they have to have knew or should have known of the sexual abuse or exploitation by the person convicted of the crime. And 4, allow the sexual abuse or exploitation to occur. So there are 4 factors that have to be met before a business or another individual can be opened up to civil liability. The second intention of the bill is to give these child victims time to process what's happened to them and find the courage and the strength, and usually probably the support from members of the community or family members to come forward and be brave enough to bring this suit. Unfortunately, we're all too familiar with these highly publicized incidents, like Senator Dondero mentioned, with Larry Nassar and USA Gymnastics, with Jerry Sandusky at Penn State. It often takes victims of sexual abuse many years or decades before they feel comfortable and have the support to come forward. And there's a plethora of reasons for this. Many of the times these victims of human trafficking or sexual abuse are groomed by their trafficker, by their pimp. They've gotten fear instilled in them of reporting or trying to escape. They've been isolated from their family members or their friends, so they have no support if they do try to escape or report. They're oftentimes convinced by their pimp or trafficker or abuser that they deserved it. And unfortunately, a lot of these young victims become loyal to those abusers. And they rely on them for their basic survival. So, when it comes down to timeline for reporting, every victim is going to come to, if they find the strength and bravery, they're going to come to it at different points in time. And we know that this type of abuse and trafficking has lifelong effects on these children. And so if they're lucky enough to find the courage and the support to come forward, it could take years or decades for that to happen. And so Section 1 of the bill removes the statute of limitations for these types of civil claims to give victims time to seek the justice that they deserve. So in sum, we believe the bill will protect children in Nevada. It targets not only pimps and abusers, but the businesses who turn a blind eye to this criminal activity and sexual abuse and exploitation of our children. It expands the scope of liability and removes the statute of limitation so that we can go after these bad actors, we can get victims the justice that they deserve. So we urge your support for SB 203, and myself and Mr. Eglett are happy to take any questions from the committee.
Madam Chairman, this is Robert Eglett. Thank you for allowing us to testify about this bill today. I don't have much to add. I think that Senator Dondero and Ms. Brazier did an excellent job of laying out the facts about the bill. I just want to add a couple of things, and that is just to echo the fact that these children, when this happens to them at a young age, it affects them dramatically throughout their life. You see, there's many studies on this. The children fail in school, they fail in work, they fail in life. Many of them become drug abusers and just have problems throughout their lives. The other thing is that 25 to a third of the victims never come forward during their entire lives on this. And the average victim who has had this type of experience as a child, the average time of when they actually report this is not until they are 52 years old. So they either are not able to come forward with it, don't have the strength to do it, or they repress these things. I do want to clarify one thing when Ms. Brazier mentions hotels. I want to be clear to everybody that we do not, I have not seen, and we've reached this research is a great deal. We do not believe this is a problem on any of the strip properties. I'm not saying that there may not be some prostitution that goes on in some of the rooms there. That's not the issue. But we're talking about children with child trafficking, and there's no evidence that I've seen that that's any sort of problem on strip properties. But where it is a problem are these lower level off-strip properties where we know the managers are in on it, they're getting kickbacks, or they're turning a blind eye to allowing pimps to run these children through these places of business, as well as truck stops and other businesses like this. Nevada has one of the worst problems in the state. This is a nationwide problem, but Nevada is clearly at the top of some of the problems across the country. We have to have a way to fight this problem more than just the criminal justice system. This bill and these same types of bill are being presented or have already been passed in a number of other states across the country to try to combat this problem of human trafficking. With this bill, it presents a huge deterrent to these businesses from stopping that activity or making sure it doesn't occur on their premises in the future. And that is the purpose of this bill, and I hope the committee will consider that. Thank you. And again, I'll answer any questions anyone has.
All right. Thank you so much. I see we already have a couple of questions. Let's start with Senator Orenshaw.
Thank you, Chair, and thank you, Senator Dondero-Lupe, for bringing this bill. My question for either Ms. Brazier or Ms. Eglett, if the proposed changes become law, do you see perhaps victims who had been trafficked decades ago, and maybe there's a situation where there was like I said, a truck stop or some other business, nightclub, that allowed this to happen, where maybe a prosecutor might not feel that they've got what it takes for a criminal case, but where a civil action could be successful, and there'd be the outcome of trying to make the victim whole, but also trying to make sure that whoever let that happen doesn't let that occur again. Do you think that some victims who were trafficked decades prior might benefit from this, where a prosecutor might not feel that they can win the case, but a civil action could be successful?
Yes, Robert Eglett, Madam Chairman. And thank you, Senator Orenshaw, for your question. It's a very good question. And yes, I do think that's the case. As everybody knows, the burden of proof for the prosecutors is beyond a reasonable doubt. It's a much higher burden. And in this statute, we've got both knowledge and constructive knowledge. In other words, either they knew or they should have known that this activity was going on in their business. And so I do think this provides an avenue in conjunction with the criminal justice system to try to deter and reduce this problem in our state. And and so, yes, Senator, I do believe that is a possibility, and quite frankly, a probability that will occur.
Thank you, Chair. Thank you, Mr. Eglett.
All right, Senator Hanson.
Thanks, Chair Scheibel. Actually, six terms, we have talked about child sexual trafficking from my very first section, every single session. So I would love to have somebody go back and review the laws we already have in place and see if they've been effective at all in any kind of reduction in this horrible thing. It just seems we keep adding more and more laws. Now this law is a little unique. When we talk about changing it from when Senator Rondero Loop mentioned the 20-year thing, it was 20 years on top of 18 years within a 20-year window. And we did that as a compromise because there is supposed to be in criminal law a presumption of innocence. So under civil law, though, we now are changing the bar substantially. And I'm glad Mr. Eglett mentioned that, because Ms. Brazier mentioned, quote, businesses that turn a blind eye are the real focus of this, it looks like to me. And then Mr. Eglett mentioned that the strip casinos are supposedly not. The strip casinos are totally guilty of this, okay? I'm just going to make that assumption and straight up say the strip casinos know about prostitution going on their sites. I can't say every one of them, but I know enough people that work in those casinos that will make it very clear that they are not innocent when it comes to illegal prostitution in their units. So I guess my biggest issue with this is by changing the burden from essentially a presumption of innocence under criminal law, and you have to prove that beyond a reasonable doubt, to dropping the bar so substantially. Can somebody out there explain to me one thing? Is this supposed to kick in after a criminal conviction? Or is this only can this apply anytime in the next a lifetime of the individual that is a victim?
Madam Chairman, Robert Eglett, I can answer Senator Hanson's question, and thank you, Senator Hanson, for the question. If the perpetrator of the actual act, the person who had sex with the underage child, is criminally convicted, that criminal conviction for purposes of this statute is conclusive proof that the sexual abuse actually occurred. And then in the civil action, the victim would have to establish all four of the conditions. They're conjunctive, not disjunctive. And in other words, it's and, not or. All four of these have to be met. And with respect to D, allowed it to happen, myself and Ms. Brazier had a constructive meeting with members of or lobbyists for the Resort Association yesterday, where they suggested some language that we think is constructive and appropriate. Basically, it makes that section say, or that part, D, say that they failed to take steps to stop or abate this sexual abuse or exploitation after the person knew or should have known the circumstances described in sections sub A through C. And we believe that's a constructive proposal. And they also made some suggestions about, with respect to the description of the type of people that would have to know. There was some discussion about senior management. And so we're both sides are going to wordsmith that issue. But yes, it is true that this would be open for life for these victims to bring this action. But as I said, most of these victims, or at least on the average, they don't come forward till they're 52 years old. And while we appreciate what the legislature did last time in increasing it to 20 years, that's still age 38. And you are going to have a tremendous number of victims who can't seek justice. And we feel that removing the statute completely adds to the deterrence value of the bill.
Well, thank you, Ms. Reglet. And I certainly want to do everything humanly possible to reduce this to zero and punish aggressively the people that are the perpetrators. My last question for you, sir, is if you talk about somebody, for example, that it's in their 50s for acts that occurred at 18 and you find there's a repetitious pattern, is it possible for you to actually have, for example, a class action lawsuit against a strip casino or some other type of business that may have been involved in this type of stuff, whether directly or indirectly?
Madam Chairman, Robert Eglett. Thank you, Senator Hanson. I know, as you may or may not know, Senator, I do quite a bit of class action work, so I'm very familiar with that work. And you have to have typicality and commonality, and the damages have to be very similar, and it has to really arise out of the same event, the same conduct within a limited period of time. I can't imagine any court ever certifying that type of case as a class action under our current class action laws, both in state and federal court. I just don't see how that could be done. So I just don't think that is any sort of potential issue or problem.
Thank you.
These cases would have to be brought on an individual basis to have any hope of success.
Very good. Thank you for putting that on record, and thank you, Madam Chair.
Absolutely. Go ahead, Senator Pickard.
Thank you, Chair Scheibel. And I just first want to say it's good to see Ms. Brazier and Mr. Eglett being a member of the NJA. I probably align pretty well with the bill. I do have a couple of concerns. We've got a fairly detailed definition of sexual contact, and I was looking through some of the other places that shows up in the statutory scheme, and this is a little bit different. It's broader than what we typically see in the criminal law. And so is there any concern that because we've got a different definition, it might create some difficulties in the litigation process?
Madam Chairman, Robert Eglett, thank you, Senator Pickering. I don't believe so. As long as the definition is met under this statute, it doesn't have to completely, be exactly the same as the criminal statutes. And I agree there are varying definitions or varying words used, but it's defined. The definition is defined in the statute here by itself as to what the sexual abuse or sexual exploitation is.
All right, and I appreciate that. My concern was only that if it might create a defense where someone was convicted under a different standard, now we're applying that here, and yet we're claiming it's conclusive evidence. But that actually leads to my next question, which is about if we're going after these lower level, I think in one of my conversations, we were trying to define skanky hotels, those that really harbor and help these perpetrators. I'm concerned that by the first prong of the four-prong test, or the first factor of the four factors that have to be met, we might be excluding a number of them in that if they have to be employed or supervised or otherwise having some legal responsibility, that's going to exclude a lot of them who simply, under that wink, wink, nod, nod, go ahead, do your thing and give me your kickback. There's no responsibility there. Are we defining in this responsibility to include that wink, wink, nod, nod and facilitating of the behavior? Is that going to be the standard for responsibility here, or is responsibility, because I don't see it defined anywhere in the bill. My guess is then it would take the ordinary meaning, which I think would mean that they have to have some legal responsibility over the individual, which would exclude most of these places. How do we reconcile that?
The legal responsibility over I'm sorry, Madam Chairman, Robert Eglett, Senator Pickering, the legal responsibility or employment under the statute is for the person working in the motel, let's say a motel or managing the truck stop, who knows about what's going on. He knows that pimps are running these children through the truck stops and the parking lots and putting them in the cabs of the trucks with these truck drivers. They know it's occurring. Some of them are getting kickbacks from the pimps. Some of them are just getting more business from the truckers knowing about this, going to this truck stop. And the same with these motels. The manager or the owner of the motel is getting more business because the rooms are being rented, so they're getting a benefit from this. It's not that the pimp is employed by them, it's the manager or the employee in charge that knew about this and either turned a blind eye or was getting some benefit to it.
Well, and that's exactly, you just hit on the point. And that is, if we're talking about the employees, how many times is the employee who is merely turning the blind eye, how many times are they convicted of the crime? I've not.
Well, they're not convicted. They're not criminally convicted of, I'm sorry, Madam Chairman, Robert Eglett. Senator Pickering, they're not normally convicted of a crime, and I'm not sure there's a criminal statute on the books for that. And that's why this bill is so important to help to deter this, and we think will be significant deterrence to this type of conduct, so that owners of these businesses and managers who work in these businesses know that they will be subject to civil liability if they continue in this type of conduct. Right now, to my knowledge, and I'm not a criminal lawyer, but to my knowledge, I don't think there is a criminal statute where a prosecutor could go after that manager or that employee.
Okay, and so I think you've confirmed that because of factor A, and because we're not convicting that essentially the co-conspirator, we couldn't apply this to any of those stanky hotels, let alone the resorts that, and we've heard many times over the sessions I've been here, where the resorts are supposedly, and I don't know if they are, but we've heard repeatedly that they know this is going on in their facilities. So, but under the way sub A is written, I don't see how because we don't convict them, now this doesn't apply because that's one of the necessary factors.
No, the conviction is of the conviction is of the John or the pimp. The criminal conviction is if the John is convicted or the pimp is convicted. It's not a criminal. You don't have to have a criminal conviction of the manager or the owner of the business. As long as they had knowledge or constructive knowledge of this, you don't have to convict them for them to be liable. I think it's you're a little bit confused about the statute, Senator.
Well, and I'm just reading the language. It says a person is liable to a plaintiff for damages if the person employed, supervised, or had responsibility for the person convicted of the crime. So as I read that, you have to be an employee or a supervisee or someone under the responsibility, and or the person having responsibility over the person convicted. So if you're convicted, that person either has to be an employee or supervised or under the responsibility of the owner. And in what you're describing, that's not how I read it. And maybe this is a question for legal to LCB legal to get on the record in support. But that's confusing to me, and I'm law trained, and I can only imagine what this will do. So I think we need to probably look at that language. I have a few other questions, Madam Chair, but I'll take those offline. Thank you.
All right, thank you. I also have a couple of questions and a few things that I want to clarify. And I'm not sure, Ms. Brazier, Mr. Eglett, if one or both of you could clarify this, but I just want to get on the record that this law applies simply to civil actions, and those civil actions take place in a completely separate lane. They are a different proceeding than the criminal action. Is that a fair characterization?
Yes, Madam Chairman, Robert Eglett, that is a fair characterization, correct.
So
if the chair wouldn't mind, if I could just go back to what Senator Pickering was saying, and he's looking at Section 2, Paragraph 1, which reads, if a person is the victim of a sexual abuse or exploitation, a person has been convicted of a crime arising out of such sexual abuse or exploitation of the plaintiff, and the plaintiff commences a civil action against a person other than the person convicted of the crime, then the judgment of conviction of the person convicted of the crime is conclusive evidence in the civil action that the person convicted of the crime sexually abused or exploited the person. 2, a person is liable to a plaintiff for damages if the person there we're talking about in the bill is not the person convicted of the crime, it's the other person.
Right. So let me ask a couple of follow-up questions here to see if we can try to get some clarity on the record. Because we have these two separate lanes, the civil case and the criminal case, but the bill does reference the outcome of a criminal case. Is it fair to say that that's because they arise out of the same facts?
Sure.
Well, yes.
Okay. So there's some benefit as lawmakers to thinking practically about the fact that when both of these cases come before two completely different courts and completely different judges, that they will be operating from some of the same evidence. For example, the same statements, the same videos, the same emails, the same text messages might be shown in one case as in the other to show that, for instance, sex trafficking had occurred. Is that kind of the reason for incorporating parts of the criminal statute or acknowledging the criminal aspect of the statute in SB 203?
I'll also read for the
Go
record.
ahead, Al.
Yes, I think that's a fair characterization of what we're intending to do. I mean, we know that the gathering of evidence, especially in a police investigation, is going to get a lot of what a plaintiff would need in a civil case. It doesn't, the way the bill is written, you don't have to have the criminal conviction to then pursue the civil case. But if there is a criminal case and a criminal conviction, then that evidence and that conviction can come in for the civil.
And so, am I correct? That would essentially prevent the court from having to do a trial within a trial to show that the sex trafficking occurred when it's already been proven beyond a reasonable doubt. Or, I'm sorry, the sex trafficking or abuse or rape or any other kind of sexual contact. This would alleviate the necessity to do a trial within a trial on those facts because they had already been proven beyond a reasonable doubt in criminal court. Is that fair?
Robert Eglett, Madam Chairman. Partly true. The criminal conviction of the John or the pimp is conclusive evidence, but in the civil case, the victim would still have to prove all 4 of the elements set forth in Section 2 of the statute, the A, B, C, D factors. So there would still have to that evidence, either constructive, actual or constructive knowledge, and that the person was employed or supervised or had responsibility of the person convicted of the crime, etc. All of those things. And I now seeing what Senator Pickering was saying, and there may be some wordsmithing we have to do to kind of fix this a little bit.
I'm not sure if there is. I want to have a clear record. So, for example, let's say I am a person who has been sex trafficked and I want to bring a suit against the owner of the motel where I was trafficked. What you're saying is there are 2 ways to go about it. If there has never been a criminal case, then first I have to prove that I was trafficked there. And then I have to meet the 4 subsections of Section 2, subsection 2, to prove that the motel owner had responsibility for that person, owned and controlled the property, knew or should have known and allowed the abuse to continue. That's one route. The other route is if that person was already convicted, whether it was last year, last month, or 15 years ago, I can bring in the judgment of conviction and say, look, I was a victim of sex trafficking. Now that I've gotten past that first hurdle, let me show you how I meet the second set of hurdles, that where this crime occurred was at this motel and the owner was responsible for the person, controlled the property, knew, should have known, and allowed it to continue.
That's Robert Eglett, Madam Chairman. That's accurate.
Okay. I have one more question for you both. And this is kind of like a law school hypothetical because you are both very experienced civil attorneys and worked on many, many civil cases, which I have not. But I am trying to imagine another scenario in which somebody is responsible for a venue, a place, and they're responsible for the people inside who may not be employees or supervised. And so my hypothetical that I'm going to try to draw a parallel between is, let's say I'm the owner of a gym and there's somebody at that gym who is just sexually harassing the women who go to the gym. Could that gym owner be held liable for allowing that harassment to continue?
Madam Chairman, Robert Eglett, well, this bill doesn't really address sexual harassment. This is sexual abuse or exploitation, which is defined clearly in the bill. And I'm not a labor lawyer or an employment lawyer as to whether just under the law currently, if the gym owner would have some liability for that if one of his customers was sexually harassing another customer, but that's a different issue than sexual abuse or exploitation.
Ms. Brazier, what do you think?
Allison Brazier for the record. I agree with what Mr. Eglett said. I think maybe to just help with the hypothetical a little to make it more apt to this situation would be if there was a gym owner and in your case, it was a customer who was, maybe sexually abusing children at the gym repeatedly. In that case, I think you would need to look at subsection 2 to understand, what did the owner know or should have known? What did they do in response to that knowledge or that activity? So I think that's where the subsection 2 and the 4 factors come in to analyze, if we are making business owners or other individuals responsible for criminal activity of another, that's why we put in these 4 factors so that it's not a free-for-all. You've really got to be able to prove all 4 of these things and that the business owner or the individual turned a blind eye and allowed this abuse or exploitation to continue to happen.
Okay, and I think I'm most concerned about section 2, sub A, where the person, the defendant in this civil case has to have either employed, supervised, or had responsibility for the person convicted of the crime. I interpret that broadly to mean that a property owner has responsibility for their customers, their patrons, the people who frequent the establishment. And I want to make sure that that understanding is correct, because if it's not,
all of the strip.
Because if it's not, then I think that we would be missing some of the people this bill is intended to include.
Madam Chairman, Robert Eglett, again, I think Senator Pickard has a point about Part A, and I think how that needs to be wordsmithed. I don't have the words in front of me right now, but it really shouldn't be employed, supervisor, had responsibility for the person convicted of the crime. It should be employed, supervisor, had responsibility for the person who knew or should have known that the activity was going on at the premises and failed to take any steps to abate or stop it. Turned a blind eye or was getting a kickback. And unfortunately, we're just seeing that where the way it came out of LCB is not really how it was intended. But the other thing I do want to stress with the hypotheticals that are being thrown out there, this bill is directed only toward minors or who were minors at the time of the sexual abuse or exploitation, not adults where this is going on in these facilities. So I understand what Senator Hanson said about the strip hotels, that they may know that prostitution is going on. I just am not convinced or have seen a lot of evidence that child prostitution is going on at those properties. And that's the difference.
Thank you. Senator Pickard, I see your hand, but with our short timeline, I'm not going to do second bites at the apple today. I'll ask you to follow up offline. Is there anybody else who has questions for the presenters? All right, seeing none, we will move to testimony in support of SB 203.
Thank you, Chair Scheibel. To testify in support on Senate Bill 203, please press star 9 now to take your place in the queue. Once again, to provide support testimony on Senate Bill 203, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 377, please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon. My name is Deshaun Jackson, Dashun Jackson. Good afternoon, Chairwoman Scheibel and members. I serve as the Director of Children's Safety and Welfare Policy with the Children's Advocacy Alliance. And the Children's Advocacy Alliance supports Senate Bill 203. We believe this bill is extremely important to the victims of sexual offenses. Children that have been sexually abused experience trauma and fear that prevent them from speaking up. This bill would allow these innocent victims the opportunity to heal and get the justice they deserve. Thank you all so much for hearing this bill and support. Thank you so much.
Thank you, caller. And as a brief reminder, we are currently on support testimony for Senate Bill 203. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue.
Mr. Kyle, I'm going to interrupt you because I forgot to ask the record to reflect that Senator Settlemyer has joined us. He joined us quite a while ago, and I didn't want to forget to make sure that he was marked present for this meeting. Back to you.
No problem. Thank you, Chair Scheibel.
Next time, shoot me questions you want to ask, and I can.
Caller with the last 3 digits, 207. Please press star 6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Madam Chair and Judiciary Committee members. My name is Catherine Robb, KATHRYNROBB. I'm the Executive Director of Child U.S. Advocacy. I'm a mother and I'm also a survivor of child sexual abuse. At Child U.S. Advocacy, we work on child protection legislation all over the country. There is a national trend by lawmakers in responding to the epidemic of child sexual abuse, which presently the data and research says that 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. That is 13% of all children. Since 2002, 37 states, the federal government, and D.C. have extended their statute of limitations. 21 jurisdictions have revived their civil statute of limitations, and 13 jurisdictions have eliminated their statute of limitations for child sexual abuse. This year, as of today, 30 states have already introduced statute of limitation reform. 17 of those are revival legislation. So the national trend is clear as to this epidemic of child sexual abuse. And the sky has not fallen. Others will cry, the courts will be flooded. The courts have not been flooded. Others will cry, we don't do this for other torts. Well, these are not car crashes, slip and fall cases. We're talking about the assault and rape of children. These are very different civil wrongs that silence the victims. Think of them as a repeated intentional car crashes that damage and traumatize children for their entire lives. Others will also cry, institutions and organizations will go bankrupt. Well, bankruptcies are Chapter 11 and they are voluntary and they serve the wrongdoer. It gives them a new day. They do not serve the victim. Victims become a number on a spreadsheet, their voice is lost, the wrongs of others are kept secret as there is no discovery. And meanwhile, victims, society, and taxpayers bear the financial burden of the cost of child sexual abuse. Others will also cry, it's not fair, due process. Thank you.
Thank you, caller. If you've recently joined us this afternoon, we are currently on support testimony for Senate Bill 203. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 540. Please press star 6 to unmute yourself. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Madam Chair, members of the committee. My name is Serena Evans, spelled SERENA-EVANS, and I'm the policy specialist at the Nevada Coalition to End Domestic and Sexual Violence, and we're here today in support of Senate Bill 203. There is no statute of limitation for the pain and trauma that victim survivors of sexual abuse or exploitation feel, so it only makes sense to ensure that there is no statute of limitations for which these victim survivors can seek restitution to recover damages caused by their victimization. We're also in favor of adding the definition of sexual contact to include other sexual acts like unwanted and inappropriate touching. We know that all victim survivors' experiences of sexual violence are different, and it is important that we recognize the different experiences of each survivor in our statute. Thank you very much.
Thank you, caller. If you've recently joined us this afternoon, we are currently on support testimony for Senate Bill 203. If you'd like to provide support testimony at this time, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 945. Please press star 6 to unmute. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin. And that caller has left the queue. So with that, Chair Scheibel, there are no more callers to give support testimony at this time.
All right, thank you so much. In that case, we will move on to testimony in opposition to SB 203.
Thank you, Chair. To testify in opposition on Senate Bill 203, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 781. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. Nick Vanderpool, NICK-VANDERPOEL with Capital Partners, today representing the Reno Sparks Chamber of Commerce. While the Reno Sparks Chamber of Commerce is very much against sexual abuse and exploitation, we have some concerns that we need addressed, and we will work offline with the bill sponsor and the parties involved to shore up our concerns. Chair and members of the committee.
Thank you, caller. If you've recently joined our call this afternoon, we are currently on opposition testimony for Senate Bill 203. If you'd like to provide opposition testimony at this time, please press star 9 now to take your place in the caller with the last 3 digits, 139. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may.
Thank you, Chair Scheibel and committee members and Senator Dondero Loop for bringing this important bill. Misty Grimmer, GRIMMER, with the Ferraro Group representing the Nevada Resort Association. We very much appreciate the gravity of this bill and the goal of holding the people responsible for these crimes accountable and the people who could have stopped these crimes if they were in a position to do so. Unfortunately, as currently drafted, we are in opposition to SB 203. We have started conversations with Ms. Brazier and Mr. Eglett. As Mr. Eglett mentioned, we had a constructive chat yesterday and look forward to continuing those conversations. The crimes described in this bill are horrible crimes, and it's important to hold the responsible parties to task. But since these crimes are so horrible, it's also important that people who were not a party to these terrible acts are not unintentionally pulled in as having been so. That is the balance we are seeking in our discussions with the sponsor and the proponents. We look forward to continuing those, and we thank the committee and Senator Dondero Loop for bringing this bill, and thank you for your time and consideration.
Thank you, caller. Caller with the last 3 digits, 888. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Good afternoon, Chair Scheibel, members of committee, Senator Dondero Loop. This is Peter Kruger, Peter, P-E-T-E-R, Kruger, K-R-U-E-G-E-R, on behalf of the Nevada Petroleum Marketers and Convenience Store Association. During today's testimony, truck stops and other fueling sites have been singled out as hotbeds for youth trafficking, and we don't dispute that. We, as an industry more than 10 years ago, have joined with the Truckers Against Trafficking and other groups to do things which I hope would qualify as not turning a blind eye, but for example, part of Truckers Against Trafficking programs include posting signs with phone numbers to the national hotlines, posting other kinds of signage. We use security patrols. I don't think the average member of the public or anyone realizes that a truck stop is anywhere from 10 to 20 acres in size. And for when a owner who could be a corporation many miles away or the management of that daily facility employs some tactics that we feel are go in the right direction, but whether they would meet the legal challenge of turning a blind eye, we're not sure and would like clarification of that. But there are things that are being done. This is a very wide net. I am happy to hear that there are discussions, and we'd like to be part of them, because it's one thing to call bad actors out, but there are also lots of businesses, the majority of business, and all of our members who are trying to do the right thing and preventing this dastardly crime. So with that, we'd like to continue the dialogue, and thank you for your time.
Thank you, caller. Caller with the last 3 digits, 580. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Chair Scheibel, members of the committee, for the record, my name is Paul Enos, E-N-O-S. I'm the CEO of the Nevada Trucking Association, and we're speaking today to oppose Senate Bill 203, and really it's on the Section 2, Sub 2, where we do have the issues. In terms of employed or supervised, head responsibility, we do hire a lot of independent contractors, and we do wonder, would they be covered under this? We have had some conversations with NJA and are hopeful that we can come up with some language that works. I do want to say the Nevada Trucking Association back in 2012 became the 3rd trucking association in the country to partner with Truckers Against Human Trafficking. Since then, we have trained nationwide through that program over 1 million truck drivers to recognize and report the signs of human trafficking. And it's something that is very important to us. Unfortunately, Nevada, because of the large number of visitors that we have, because of the transitory nature, we do end up as a hotbed for human trafficking. And it's something that we as an association, we as an industry absolutely are in the fight to end human trafficking. Our truck stops are some of our best partners, and we appreciate continuing the conversation to see if we can make this a little bit of a better bill and clear up some of the language in Section 2. Thank you.
Thank you, caller. And for any callers just joining us, we are currently on opposition testimony for Senate Bill 203. If you'd like to provide opposition testimony at this time, please press *9 now to take your place in the queue. Caller with the last three digits, 648. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair Scheibel, members of the committee. My name is John Jones, John Jones, and I'm here on behalf of the Clark County District Attorney's Office. And based on the rules of the committee, we are here in opposition to SB 203, but we are very much in support of the intent of this bill and completely support the idea of giving child victims of sexual abuse and exploitation the space and time they need to recover from the pain and trauma afflicted by their abuser and those who allow the abuse to occur. We have reached out to Senator Dondero Loop and the Nevada Justice Association with a few concerns, and we appreciate their willingness to work with us. We are requesting some language and definitional cleanup and some clarification that the governmental immunity and liability provisions located in NRS Chapter 41 inclusive apply. Again, we are supportive of the intent behind the bill and are more than willing to continue working on a potential resolution. Thank you.
Thank you, caller. Caller with the last three digits, 700. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair, members of the Senate Committee on Judiciary. My name is Brian Wachter, BryanWachter. I appreciate the Senator bringing this bill forward. It has been something that the Retail Association has been working on. We were happy to support legislation in the last session, and we've also been supporting legislation in the other house that hopefully will make its way to you in order to combat this horrific problem. We do believe that there needs to be some clarification in the language, and we were excited to note that during the hearing we believe that became evident, and so we are going to be looking for that new language. You know, we believe that this is a repugnant act, and we certainly don't support anyone who engages in it. We do question how effective a deterrent will be if someone is willing to engage in this most horrible of activities, whether or not that civil liability is going to be enough to deter that behavior. But we are interested in helping solve this problem, and we look forward to the continued discussion.
Thank you, caller. Caller with the last three digits, 945. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Hi, my name is Chris Wakefield, ChrisWakefield. I'm a researcher at UNLV who's been working on sex offense policy issues both in Nevada and across the country for the past 5 years. I've provided a more detailed exhibit, which I encourage the committee to review, about this law. SB 203 looks like a bill that would do a public good by expanding the ability of victims to pursue civil damages. In practice, SB 203, is based more on dramatic media stories than on the majority of sex offenses it will apply to, which has gone unaddressed by this committee today. To be clear, the research shows that these policies will not do anything to defer human trafficking or sex offenses. Instead, this law will disproportionately harm Black men in Nevada who are more likely to be punished for sex offenses and economically destabilize sex offenders more generally. Doing so carries with it the risk that sex offenders will end up rejecting lessons from treatment programs or investment in legal systems that keep sex offenders from reoffending. Take one of my participants, Andy, a Black man in his 60s who would be a common target for this law. After Andy's conviction, he couldn't return to his previous job, and he ended up working a landscaping job for close to minimum wage for many years. Now most of his income is Social Security, and he cannot work. He has already lost his wife, his family, friends, home, career, and the ability to engage with the community. If SB 203 is passed, he will not have the funds to defend himself, nor could he pay for damages if he was sued. He will likely end up another sex offender on the street where we cannot track him. 10% of the registry is already housing unstable or homeless, a number we can't afford to increase. If the members of this committee have any investment in the criminal justice reform that so many in our state took to the streets to fight for this year, we do not get there by creating unlimited liability that never allows an offender of any type to rebuild and reintegrate into society. Thank you.
Thank you, caller. A brief reminder, we are currently on opposition testimony for Senate Bill 203. If you'd like to provide opposition testimony, please press *9 now to take your place in. Caller with the last 3 digits, 725. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Good afternoon, Madam Chair, members of the committee. For the record, this is Andrew McKay, ANDREW, MACKAY, representing the Nevada Franchise Auto Dealers Association. I am here to speak in opposition, emphasis on tepid opposition, because we believe the intent of this bill is spot on, and applaud Senator Dondero Loop for bringing it forward. I know that you all are very pinched for time, so I believe our concerns with respect to the bill, namely in Section 1, Subsection 2, and some of the language in there that needs to be massaged, as alluded to by Mr. Eglett. Those have been covered at length. Again, thank you to Senator Dondero Loop, and then also to Kaylin Gardavani for spending some time with me this morning on the bill as well. Thank you.
Thank you, caller. Caller with the last 3 digits, 124. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. Paul Moradkin, Moradkhan, with the Vegas Chamber. First, we'd like to thank the bill sponsor for bringing the bill forward. Please note that we do not have any issue with the intent of the bill and condone, of course, these type of activities. I'd like to reiterate the comments made by several of my colleagues that are concerns about clarifying some of the language that has been discussed today. Thank you for your time this afternoon, Chair and members.
Thank you, caller. Caller with the last 3 digits, 113. Please press *6 to unmute yourself, then slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Good afternoon, Chair Scheibel and members of the committee. Carrie Silverman, CARY-SILVERMAN, on behalf of the American Tort Reform Association, ATRA. ATRA has no issue with providing survivors of childhood sexual abuse with a lengthy period to bring civil lawsuits. What we are concerned with in this bill is the complete elimination of a statute of limitations and the revival of claims after the time to file them has ended. Tort law often deals with serious injuries that dramatically change a person's life. A medication may have caused a birth defect. A person who's diagnosed with cancer may attribute it to a consumer product or environmental contamination. A car accident kills a parent or a child, possibly as a result of a defect. In each of these situations, Nevada law has a finite period to file a lawsuit, usually between 2 and 4 years. For childhood sexual abuse claims, Nevada provides far longer, setting a 20-year period beginning at age 18. It will always seem unfair to tell someone who's been harmed that it was too late to file a lawsuit, but we have statutes of limitations so that judges and juries can make decisions about liability based on the best evidence available when witnesses can testify and before records have been discarded. And it's understandable to view childhood sexual abuse as involving such horrific conduct that there should be an exception to the rules that we apply to every other type of civil lawsuit. But if Nevada law eliminates the statute of limitations here and revised time-barred claims, you can expect others to seek similar treatment, and we're starting to see that. For these reasons, as well as constitutional concerns, most state legislatures have rejected similar proposals and instead adopted longer periods that apply prospectively, as Nevada has done in the past. Few states have completely eliminated their statute of limitations, and while about 1/3 of states have revised time-barred claims, many of these laws have significant constraints on the types of claims that are revived. Those types of constraints are not in SB 203. I've submitted written testimony that expands on these points, and I thank you for the opportunity to testify today and welcome any questions.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give opposition testimony at this time.
All right, thank you so much, Mr. Kyle. At the risk of closing the barn door after the horse has already fled, I do want to let everybody who has been calling in to testify and everybody who's watching this meeting know that on the Senate side, we do not have rules about testifying in opposition if you have a problem with one part of the bill or a concern about one part of the bill. We do leave it up to our individual testifiers or witnesses to determine where they best fit, if that's neutral or opposition. And so I just want to make sure that you guys know that moving forward. With that, we will close opposition testimony and we will move on to neutral testimony on SB 203.
Thank you, Chair. To testify in neutral standing on Senate Bill 203, please press *9 now to take your place in the queue. Once again, to testify in neutral on SB 203, please press *9 now to take your place in the queue. And Chair, there are no callers to give neutral testimony on SB 203 at this time.
All right, well, thank you very much for your help, Mr. Kyle, and thank you to everybody who took the time out of their day to present this bill, answer questions on this bill, ask questions about this bill, and to call in about this bill. With that, would the presenters like to make any final comments, respond to any of the testimony?
Yes, Madam Chairman, Robert, I'm sorry.
Go ahead, Mr. Eglett, and then I'll close.
Thank you, Senator. Madam Chairman, thank you. I just want to actually point out that I appreciate Senator Pickard's sharp legal eye and on the problem with the one section, the vagueness of it. And so we will work with that. And again, we're obviously willing to work with the groups who have some concern to try to address their concerns with them offline. We thank you for your time today.
Chair Scheibel, to close, I would just say that the survivors of child sex abuse and exploitation deserve a civil forum to pursue their abusers and those allowed to abuse and to exploit them. And we know that there will be some amendments that are offered to this bill, and we thank all of those involved, and thank you for your time today.
Thank you, Senator Dawn Darrow-Loop and everybody else. With that, I will now close the hearing on SB 203. And as always, our presenters and our guest senators are welcome to stay with us for the rest of the meeting or move on to other important tasks of the day. And we will now open the hearing on SB 223. Senator Harris.
All right. Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Dallas Harris, and I represent Senate District 11 in the southwest part of Clark County. It's my pleasure to present Senate Bill 223 to you today. Senate Bill 223 codifies a defendant's right to be judged by a jury of their peers. During the process of jury selection, attorneys for both plaintiffs and defendants have a limited number of opportunities to strike potential jurors without providing a specific reason through what are called preemptory challenges. While the Supreme Court has ruled such challenges to exclude a juror based on their race or gender is unconstitutional, neither the Supreme Court nor federal law explicitly prohibit discrimination in jury service based on other characteristics such as sexual orientation or gender identity. Such discriminatory treatment undermines the justice system and could hurt crime victims by preventing a fair trial by a jury of their peers as well. This could have particularly negative impacts on victims or defendants who are lesbian, gay, bisexual, transgender, or queer. The right to a trial arbitrated by a jury of one's peers cannot be truly realized without protections from discrimination during the process of jury selection. Preventing individuals from participating in juries simply because of their sexual orientation or gender identity or race infringes on the fundamental right to an impartial jury and to the reciprocal right to jury service. Currently, there are 11 states that prohibit discrimination on the basis of sexual orientation in jury selection, while 8 states prohibit discrimination on the basis of gender identity in jury selection. These protections are not a new idea. They just need to be codified to be preserved. And for the legal eyes on the Judiciary Committee, I have a couple of legal citations I'd like to refer you to. Batson v. Kentucky, of course, that is the seminal case that protects race-based groups. See J.E.B. v. Alabama and Watson v. State, which protects gender-based groups. and C. Morgan v. State, SmithKline Beecham Clore v. Abbott Labs for protections of sexual orientation-based groups. I'll keep it short and sweet. With that, Madam Chair, I will subject myself to any questions from the committee.
Thank you, Senator Harris. I'll go to other members of the committee first. Senator Pickard.
Thank you, Madam Chair. I was actually under the impression this was already the state of the law, but my concern is only that is the intent to remove from the ability of a prosecutor or defense counsel to remove people from a jury based on any particular attitudes, or are they still going to be able to strike jurors because they have attitudes that might not align well with their theory of the case?
It is the latter, Senator Pickard. This would not affect that ability.
Okay, thank you.
Senator Settlemyer.
That's what happens with us. Unfortunately, Chair, we occasionally argue about who has the unmute button, and obviously you have the master one. In that respect, though, I was just kind of curious, as being someone who doesn't practice law on this committee, how do you tell that? I mean, when they do a challenge to a particular person on a jury trial, how are you going to know that they decided that they felt they'd have a better time with a completely female jury versus a completely male jury? How do you know that that was in their calculus when picking?
Well, Senator Settlemyer, I'll give it a shot. You generally won't know, although what it would be incumbent upon one of the attorneys to make a challenge based upon that, and then the judge would make a factual determination.
Okay, with that being said, if I could continue on, Chair, how do you deal with a situation where a guy is going, is up for a DUI, and he killed, sadly, in a car wreck, he killed a little girl, and it's a decision that they want to try to stack the deck with mothers because they feel it'll put the person in jail better. I mean, how do you differentiate that?
Senator Settlemyer, I'll give a quick answer, and I don't know if Chair Scheibel has any additional insights, as she practices in the courtroom much more than I do. Senator Settlemyer, often you're going to want to do something like that, maybe stack with mothers if you can. This bill would not affect your ability to try and pick the best jury in that way for your client. And so, I don't see this necessarily imposing or changing that ability at all.
But as a sponsor of the bill, I mean, it specifically states jury selection should not be allowed by stacks. And I guess we'll have to follow up online. I guess I'm just confused because I think your bill prevents that. And frankly, I have no problem with making sure. Anyways, I'm a little bit confused because I think the bill has the ability to do just that.
Well, Senator Settlemyer, I would argue not all women are mothers. And so in your description of wanting to pick someone because they're a mother, that does not necessarily overlap with discriminating on the basis of sex.
I'm willing to say that all mothers are women. So I guess we'll just have to we'll follow up offline. Thank you.
All right, Senator Harris, I also have a couple of questions. And I'm just trying to make sure that I understand the purpose here is not to address discrimination at the point of creating juror lists and creating voir dires, but it's supposed to be after the voir dire has already been impaneled, that the attorneys on the case are not using either peremptory or for-cause challenges to systematically remove people from the jury based on their sexual orientation or gender identity or age or physical disability or race or religion.
That is correct.
And is there a companion, I don't know if statute is the right word, or policy that would address that front end kind of de facto discrimination? And sorry, when I say front end, I mean the composition of the voir dire. How do we ensure that when I, as a prosecutor, walk into a room to start picking my jury, it's not already, you know, how do we ensure that it's reflective of the community to start with?
And Chair Scheibel, you're bringing up a really important point, and one that I was thinking about attempting to address in this legislation. This would probably have to reflect some changes in NRS 6.045, and I could not quite get there, but you are correct. We need to worry about both sides of the issue. This bill only addresses the latter.
Okay. And my last question, I think, is about how this bill would be enforced in reality, because generally with a Batson challenge or a similar discriminatory challenge, it is the defendant who brings the issue. First, they have to bring it during the jury trial, and then they have to bring it again on appeal and explain how not only was the striking of jurors discriminatory, but also how that prejudiced the defendant. So in this case, would it still have to be criminal defendants who were convicted, overturning their convictions by citing to the statute, or does this create a civil liability, or does this create a new class of prosecutorial misconduct, or would this also create, you know, some kind of ethical violation for a defense attorney who engages in discriminatory jury selection practices?
So I think your first point and your last point are probably the closest. I envision this working in the similar way that Batson challenges currently work today. On your last point, I could imagine some creative lawyer drafting a Rule 11 motion for sanctions based upon violation of this statute if it's blatant, and if so rises to some ethical level, as possibly the violation of any other statute by a lawyer might result in.
So just to clarify, that means that if I am kicked from, and I say kicked, if a peremptory challenge or a for-cause challenge is used to remove me from a potential jury pool, this does not give me the right to sue the judge, the prosecutor, the defense attorney who exercised that peremptory challenge on the basis of having been discriminated against.
It does not.
So that would also then require some cooperation between the person who was discriminated against and the person who is actually prejudiced by the discrimination.
Yes, if I understand your question correctly, yes.
Right, so going back to my example, if I was the person who was removed from the jury either for cause or through peremptory challenge, and then say it's a civil case and the plaintiff in the case lost, and they want to say, well, the reason that we lost is that the defense counsel struck all of the women from the jury, they would have to go find the women who had been struck and say, or I guess they would have to go back to the record and show that Melanie Scheibel was struck because she was a woman from that jury. But I wouldn't have any private right of action as the juror who was discriminated against.
That is correct. No private action for the juror for being for having a peremptory challenge used against them, only designed to protect the rights of the alleged person. And again, this is part of the reason why you see Section 1, subsection 3, paragraph paragraph B. This is not designed to grant someone a absolute right to serve on a jury or create any rights that people don't already have.
Okay, thank you. And I see that Senator Hanson has raised his hand. Please go ahead.
Thanks, Madam Chair. Just a quick question. What problem are we trying to solve here? I mean, right now, obviously, I think you practice law primarily in Clark County. The defendant's attorney obviously would want to do everything possible to get people on the jury favorable to them. Therefore, the problem, as I see this, must be the Clark County District Attorney's Office. Is there a problem with the way they're currently selecting? I can't help but note that virtually everybody that I've seen at the legislative level, at least, have been white. Is there a problem in the prosecution side in Clark County with jury selection, and is that what you're targeting with this bill?
Senator Hanson, I'll say this: both prosecutors and defense attorneys use preemptory challenges, and so both sides have an equal opportunity to say that a juror was struck unfairly under case law. What we're trying to do here is put statutory protections in place that make it clear that in the state of Nevada, you cannot discriminate based upon these factors.
So you're basically saying, in your opinion, there are no current problems with jury selection by the Clark County prosecutors?
Senator Hanson, to you through Chair Scheibel, I will say this: I have not been alerted to some flurry of issues of prosecutors striking people unfairly.
All right. Thank you, Madam Chair.
All right. Are there any other questions from members of the committee who've not asked any questions yet? I am not seeing any. So with that, we will conclude the presentation portion and move on to testimony in support of SB 223.
Thank you, Chair Scheibel. To testify in support on Senate Bill 223, please press *9 now to take your place in the queue. Once again, to testify in support on SB 223, please press *9 now to take your place in the queue. Caller with the last three digits, 611. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good morning, Chair Scheibel and members of the Senate Judiciary Committee. This is John Piro, Johnpiro, from the Clark County Public Defender's Office, testifying in support of the amended version of Senate Bill 223. I just wanted to address a few things. First, I wanted to thank the Senator for bringing this bill forward, but also to Senator Scheibel's point of NRS 6.045. That is not addressed in this bill, but it should probably be addressed because we do have a problem. And although Assemblyman Fumo tried to fix it with getting information from DETR, the Department of Employment, Training, and Rehabilitation, it is my understanding that that information is not being turned over to make more diverse jury pools. To Senator Hanson's point, your question is right on target. Neither Senator Scheibel or Senator Cannizzaro is guilty of this, but the Clark County District Attorney's Office as a whole has a long and tortured history of violating Batson and getting serious cases reversed because of their problems with that issue. And I can get those cases and lists to you in the future. So we do thank Senator Harris for bringing this bill forward. That concludes my testimony.
Thank you, caller. Caller with the last three digits, 069. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, my name is Andre Wade, ANDREWADE. Thank you, Chair Scheibel, Vice Chair, who I believe is still not there, and members of the committee. Here in support of SB 223, and like to just note that often LGBTQ folks are discriminated against for their actual or perceived identity, and so we have to be careful that we don't assume that just because someone doesn't know that someone specifically is from the LGBTQ community that they won't be discriminated against. But with these efforts across the board to increase data collection and ask people their sexual orientation and gender identity to better know disparities, people are a lot more willing to state their sexual orientation and gender identity. So it's not a taboo subject for many folks. But lastly, this bill will just help to solidify that folks can't discriminate against people for any reason, in particular around jury selection. And so we are very much in support of SB 223. Thank you, and that ends my testimony.
Thank you, caller. Caller with the last three digits, 007. Please press *6 to unmute yourself. Once again, caller with the last 3 digits, 007. Please press *6 to unmute. And slowly state and spell your name for the record. You will have 2 minutes to speak and may begin. One more time, caller with the last 3 digits, 007. Please press *6 to unmute yourself. All right, we will move on. Caller with the last 3 digits, 725. Please press *6 to unmute. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, and thank you, Chair Scheibel and committee members. This is Nick Shepek, N-I-C-K-S-H-E-P-A-C-K with the ACLU of Nevada. We first want to thank Senator Harris for bringing forth this important bill. We want to echo the comments of those who spoke before. Every defendant in state and federal court alike has the right to be tried by an impartial jury that represents a cross-section of the community and does not intentionally exclude persons of the defendant's own race, religion, sex, sexual orientation, gender identity, or expression, national origin, age, or physical disability. The ACLU has been active in ensuring fair and diverse juries since the early 1960s. This bill is one more positive step in that direction. While Batson v. Kentucky offers some protections from discriminatory jury selection, stronger protections in state statutes will help to ensure more fair juries. We urge you to support this important legislation, and thank you for your time.
Thank you, caller. As a brief reminder, we are currently on support testimony for Senate Bill 223. If you'd like to provide support testimony at this time, please press *9 now to take your place in the queue. Caller with the last 3 digits, 130. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINE-SAUNDERS, and I'm Policy Director with the Progressive Leadership Alliance of Nevada here in support of Senate Bill 223. Everyone in Nevada deserves access to a fair criminal justice process. It is essential to preserve this, that we do not allow discrimination to impede the jury selection process. We urge your support of this legislation. Thank you.
Thank you, caller. Caller with the last 3 digits, 318. Please press *6 to unmute yourself, and slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. This is Kendra Birchie, KENDRA-BERTSCHY with the Washoe County Public Defender's Office. We want to thank Senator Harris for bringing forward this bill to start the conversation about improving our jury system. As you heard Mr. Pirro mention, this is just one step that we need to make in order to ensure that our jury trials are consisting of individuals who make up a fair cross-section of our communities, that are fair, unbiased, and truly are a jury of our peers. We really appreciate the Senator's work in trying to start this progress. And for those who are interested, John Oliver recently put forward some information about just why it's important to ensure that we're having representation on our juries. Thank you so much for your time and attention today.
Thank you, caller. Going to try one more time with caller with the last 3 digits, 007. Please press *6 to unmute. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin. Once again, caller with the last 3 digits, 007. Please press *6 to unmute. Then slowly state and spell your name for the record. You will have 2 minutes to speak and may begin. All right, moving on once again. Caller with the last 3 digits, 841. Please press *6 to unmute. And then slowly state and spell your name for the record. You will have 2 minutes to speak, and may begin.
Good afternoon. This is Lisa Rasmussen, LISA-RASMUSSEN. I'm sorry, I seem to be having connection problems this afternoon, and my earlier attempt to speak didn't work. I am testifying on behalf of Nevada Attorneys for Criminal Justice this afternoon. Good afternoon, Madam Chair, members of the committee, and Senator Harris. NACJ supports the bill with the proposed amendment. I think I would say ditto in response to some of the comments from Mr. Pirro earlier in response to Senator Hanson's questions. There are problems with jury selection. There are problems with discrimination. And that is not to accuse Senator Scheibel or Senator Canizaro of any of that, but there are problems, and that's the reality. And there are numerous cases that have been reversed by the Nevada Supreme Court. I think that the bill is a good step toward correcting some of those problems. I actually don't think it goes all the way, but NACJ supports it. Thank you for letting me testify this afternoon.
Thank you, caller. And with that, Chair Scheibel, there are no more callers to give support testimony at this time.
All right, thank you so much, Mr. Kyle. We will move on to testimony in opposition to SB 223.
Thank you, Chair. To testify in opposition on Senate Bill 223, please press *9 now to take your place in the queue. Once again, to testify in opposition on Senate Bill 223, please press *9 now to take your place in the queue. And Chair, at this time, there are no callers to give opposition testimony.
Thank you. We will now go to neutral testimony on SB 223.
Thank you, Chair Scheibel. To testify in neutral standing on Senate Bill 223, please press *9 now to take your place in the queue. Once again, to provide neutral testimony on SB 223, please press *9 now to take your place in the queue. Caller with the last 3 digits, 560. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Hello, my name is David Boer, DAVID-BOEHRER. I'm with the Nevada Justice Association, and we have a neutral stance right now. We appreciate all the work that Senator Harris is trying to achieve in making sure that our juries are representative of our population and have diverse ideas and thoughts they can bring to the legislature. We also appreciate her working with us to make sure that the language works in practice, and look forward to working with her more for the language to be just right. And let me talk about a little bit. We're working with Senator Harris closely, trying to get it so that this does not infringe upon the attorney's right to pick the right jury for their case. And I think Senator Sotomayor and Senator Picker both picked up on that in their comments. And we are working closely with Senator Harris to try to make this not block your ability to try your case as you see right. So at this time, we are working with her, and we stand with the neutral position. Thank you for your time.
Thank you, caller. And as one final reminder, we are currently in neutral testimony on Senate Bill 223. If you'd like to provide neutral testimony and have just joined us, please press *9 now to take your place in the queue. And with that, Chair Scheibel, there are no more callers to give neutral testimony at this time.
All right. Thank you again, Mr. Kyle, for your help. Senator Harris, do you have any closing remarks, responses, or comments?
Yes, just very quickly, Chair Scheibel, thank you. You know, I think you hit on an important point, and that is something that I am either going to attempt to tackle next session, because I think I need to have a lot of discussions about the best way to ensure that our jury pool itself is diverse, or if I can pull off a miracle, maybe amend over on the assembly side to try and address that. But that is another issue. This is just one piece, and I appreciate you taking the time to hear the bill today. Thank you.
Thank you. And with that, I will close the hearing on SB 223. That concludes our 3 bill hearings for today and brings us to the last item on our agenda, which is public comment. Take it away, broadcast.
Thank you, Chair Scheibel. If you'd like to provide public comment this afternoon, please press *9 now to take your place in the queue. And Chair, the phone lines are open and working. However, there are no callers to give public comment at this time.
All right. Well, thank you again for your help, Mr. Kyle. Thank you to all of our committee members for a very productive set of hearings today on 3 different bills. We will be back again tomorrow with 2 additional bills to hear, and I want to remind you once again that we will be having our first Friday meeting this Friday, so don't plan anything between 1 and 3:30, and we are now adjourned.